It's worth saying from the outset, are you in this for the next 2 to 3 years, potentially, especially if the matter is actually defended?
So it's actually quite a lot longer, 2 to 3 years.
I think the big takeaway is that most oppositions don't reach the decision stage.
Have the IPO got a hand in that? Are they trying to persuade you to settle at any point?
I think so. Once an opposition is filed and the proceedings are underway, you will get ample opportunity to negotiate.
Really what you need to do is to take good advice at the start of the process before you really get embroiled. That seems to me to be a bit of a crucial takeaway from what you're saying. Hello and welcome. I'm Robert Games, Managing Director of Albright IP. Welcome to our podcast, Figure 1, an IP Conversation. Today I'm joined by Joel Weston, a trademark attorney on our trademark team, who has a particular interest in trademark opposition. Joel, thanks for joining me.
Thank you, Rob. Great to be here.
Firstly, we thought we'd have a quick look at opposition statistics, because statistics actually reveal quite a lot how people act when faced with an opposition from a legal and a business perspective. We'll then take a little bit of a more in-depth look at what an opposition decision looks like and how they're assessed by the trademark hearing officers. So, Joel, just tell us a little bit about the numbers.
Thanks, Rob. So I think before we go into the numbers, I will just set the scene a little bit on where these numbers come from. Oppositions, they share similarities to regular civil litigation, but instead of being heard in a court, they're heard in the UKIPO. There is a tribunals team there that deal with oppositions and examine the same and issue the decisions. Oppositions are filed on a form where you state your grounds of opposition and it's submitted to the UKIPO for examination.
Sure.
The hearing officers are the ones who issue the decisions. Again, they play the role of a judge essentially, but they don't sit in a court, that they sit in the UKIPO. So every year the UKIPO publish the opposition statistics as well as several other sets of data essentially regarding trademark filings, oppositions, etc. So in the 12-month period during 2024, there were a total of 6,695 oppositions were filed at the UKIPO, but out of those 6,695, only 630 actually had decisions issued in them.
Okay, so there's quite a large drop-off in the cases where decisions are issued, but it's still quite a lot of decisions. How long does it take for those decisions to be issued?
It does vary depending on the workload of the UKIPO. Quite often we'll have clients chasing when we're going to get a decision, when we're going to hear. We then call the IPO to follow this up. And the sort of general response is it's just entirely dependent on the workload. They will usually work through them in date order. So older oppositions, they're the ones that they're trying to decide first. Currently at the moment, it's taken around 12 months for decisions to be issued. So once the proceedings have closed, you will then have a decision stage. So the proceedings can take quite a few different angles at that point, but in short, it's 12 months from proceedings closing to a decision actually being issued.
Sure. So 12 months is let's face it, quite a while. So businesses need to think about whether they can afford to wait for a decision, or whether they should really actively pursue settlement.
Yeah. Again, it's something that we advise clients on when they're thinking of starting an opposition. It's worth saying at the outset, look, if we are serious here and we want to prevent, let's say, the registration of this trademark, we're not interested in settlement, or perhaps you've got a particularly aggressive client that, as soon as you say settlement, they think, oh, I'm not capitulating anything, I'm not giving anything up. And, it almost becomes the client might want to concede, essentially. They don't want to show any sign of weakness, so to speak. But at that point, you would want to say, look, we could be taking 18 months until we reach a decision stage. and then another 12 months for the decision to actually be issued. So it's worth saying from the outset, are you in this for the next 2 to 3 years potentially, especially if the matter is actually defended. So once you put that to them, they might say, okay, look, let's try and nip this in the bud in more like 2 to 4 months rather than potentially 2 to 3 years. And then you do tend to see a slight turn in revisiting the idea of settlement. And I think, as you can see, out of 630 decisions from 6,695 oppositions that were filed, a lot are settled. But I think we can discuss that a little bit more.
Sure. So I mean, okay. So it does. So that 12-month decision period, that's after you've gone through a load of other stages as well. So it's actually quite a lot longer, 2 to 3 years. And how many of the oppositions are actually successful? Because I expect that if oppositions are successful, then it might be worth waiting. Waiting for the decision rather than trying to lose ground if you think you've got a winning case. So what's the story there? What do you think about that?
Well, I'll start by reeling off some numbers. So I will refer to my notes on that. So
yeah, sure.
Out of those 670 decisions, I think it was, 271 decisions were unsuccessful, and 359 decisions were successful or partially successful. Now, out of the total oppositions filed, the bigger numbers are essentially, 2,796 of those oppositions were applications were withdrawn. So 2,796 applications were withdrawn following receipt of an opposition. This is hence why I've got my numbers written down in front of me. And 2,313 oppositions were withdrawn. So it's a fairly even split between the applicant, i.e. the defendant, and the opponent, i.e. the claimant, in terms of either side capitulating. So it doesn't really seem to be swinging one way or the other, whether the opponents are more or less likely to withdraw than the applicants. But I think the big takeaway is that most oppositions don't reach the decision stage. But when you do get to a decision stage, it's more often than not the oppositions are successful, but it's not a massive split. So 359 successful against 271 unsuccessful. So I think that sort of speaks that a lot of cases are close. It's rare that you'll get a cut and shut case reach the decision stage. The cut and shut cases are probably falling within those withdrawals of the applications and the opposition. So if you've got identical trademarks and identical goods, it's rare that an opposition like that is going to go through to a decision, because at some point within the opposition being filed and that 2 to 3 year decision being issued after the proceedings have closed, one side has realised, let's just withdraw the opposition or the application. There is no reasonable prospect of success, and let's close this out. So I think that the biggest takeaway is that after the oppositions are filed, most business owners do appear to be pragmatic, whether they're the opponent or applicant.
And do the UKIPO, obviously, I understand what you've said, that quite a few of those applications are withdrawn, or the opposition applications are withdrawn. Have the IPO got a hand in that? Are they trying to persuade you to settle at any point?
I think so, and I think that starts with our own training as attorneys. There's a general push through the way that we're taught and to handle cases that parties should always consider settlement, and as responsible representatives, you will always need to consider settlement throughout the proceedings. So even if after the opposition has filed, the party should still be considering, how can we get out of this? And that is echoed in the civil procedural rules for litigation. Settlement and mediation always have to be considered, and the IPO do allow for that. So once an opposition is filed and the proceedings are underway, you will get ample opportunity to negotiate. So that there is something called the cooling off period, whereby it is what it is essentially. It freezes the proceedings for a total of 18 months, and it enables the parties within that time period to try and reach a settlement and hopefully cool off in the interim and come to the table and with a view to either withdrawing the opposition, perhaps, or the application, or perhaps the application will register for a limited scope of goods and services.
So in your experience, I mean, with our work that we do here, do you think that are most clients open to a settlement? Is that where it really goes?
I think so. When they weigh up the likelihood of success. So I think from a case analysis perspective, when a client comes to you with a potential contentious matter, you first want to look at it and say, okay, you've got a 60% chance of success here. With the right side of the line, but it's by no means clear cut. Let's look at settlement. It's going to give us a more certain outcome. It's going to hopefully prevent us spending £5,000, £10,000, £15,000 on and years worth of arguing for them to lose, potentially lose the matter at the end once a decision has been issued. So yes, I do find the majority of clients do want to settle. Of course, if you're acting for a bigger client that has deeper pockets that will go after everything, that's even if they've only got a 20% chance of success, 10, 15, £20,000 in legal fees in a 2 or 3 year battle, it doesn't mean anything to them. They've got in-house legal teams that deal with that and deal with us. So it's it really, each client is different.
Yes.
And each one does need to be approached independently. And yeah, generally speaking, I find that parties do want to settle.
So really, in order to enable you to come up with settlement terms, really what you need to do is to take good advice at the start of the process before you really get embroiled. That seems to me to be a bit of a crucial takeaway from what you're saying.
Yeah, exactly. So I think even from the perspective of an aggressive client that wants to go all out, they still need to have good, solid advice that, here's your likelihood of success, of you winning or losing this. And likewise, good advice with regards to settlement, realistic terms that you can ask for. I tend to find it in this day and age in particular, perhaps it's a sign of the times, but a lot of clients do want financial compensation as part of a settlement. Even in my own relatively short time in the trademark profession, I have noticed a change in that. Perhaps a few years ago, people would be more happy with somebody just agreeing not to use a trademark or amending the goods that they can use the trademark for. Now it's amend your goods, don't use it, and give me £10,000 compensation for doing it. So perhaps more of a social sign of the times issue than it is particularly a legal one, but it's an interesting point that I have noticed an increase in that in recent years.
And where settlement isn't possible, what is the most sort of common ground of opposition brought by opponents?
So there are several grounds of opposition that can be brought by an aggrieved third party, or it could be brought by a rights holder. They're usually one and the same, but not necessarily. I don't intend to go into detail in all of the opposition grounds in this one because we'd be here for hours. And as interesting as I would find that, I do want to try and keep people people engaged. So we're going to be focusing on the most common ground of opposition, and that's a likelihood of confusion. So a likelihood of confusion case involves a similar trademark and identical goods or services, or an identical trademark and similar goods or services. So it's a case where confusion isn't assumed. So if we had a double identity case with identical trademarks and identical goods, confusion is assumed.
Sure.
There's not really a case there to answer it. Whoever's bringing the opposition is more than likely going to win. But where you've got some degree of difference, some point of difference between the marks or the goods, you need to prove that there is a likelihood of confusion. And that doesn't necessarily mean actual confusion. It's a likelihood. If you've got evidence of consumers being confused, that's great, and it will carry a good deal of weight, but it's proving that confusion is likely on the balance of probabilities.
Sure. So we've got a case, haven't we, that we can discuss. Do you just want to just talk us through this case, and we can start looking at some of the key findings from an actual opposition where there was likelihood of confusion was discussed?
Yep. So in this particular opposition, there were several opposition grounds raised, but as we just said, we're going to focus on the likelihood of confusion portion of that. So to summarise the case, it was a trademark opposition brought by BMW, the car manufacturer, against a trademark application filed by the Kwangyang Motor Company Limited. And BMW's trademark that they were relying on, as you might expect, it's the letters BMW. The applicant, i.e. the defendant in this case, applied to register the trademark BMU. I'm sure I don't need to explain why BMW were concerned by that. The goods that were applied for fell within the same classifications as the goods covered by BMW's trademark. And they included goods such as vehicles, motorcycles, electric vehicles, and associated software, batteries, things like that. And at a high level, the hearing officer, essentially playing the role of judge in the trademark proceedings, they found that the trademarks BMU and BMW were similar, and there was identity and some high similarity between the goods.
Sure.
On the face of it, there was a likelihood of confusion. Now, that's a high level summary. I think it'd be more interesting to sort of delve in and see how those findings were reached.
Okay, so how did they reach the decision then? Just let's go through the nuts and bolts of it.
Yeah. So the way in which hearing officers come to these decisions, i.e., is there likelihood of confusion or isn't there? It's based on well-established legal principles. For the purpose of likelihood of confusion cases, we don't see massive shifts in how these cases are being assessed now. It's quite formulaic, essentially. It goes through 5 stages. So the first stage that the hearing officer will look at are the goods and the services. So to pass this first hurdle, there has to be some similarity. It could be low similarity all the way up to identity, but to pass this hurdle, there has to be some overlap. If on this first hurdle you find the goods are dissimilar, for example, somebody applied to register tables, for example, and then somebody else wanted to register something for aircraft carriers, but they were both being filed for under the same trademark, it falls at the first hurdle, because even if you're using the same trademark on those respective goods, it's unlikely that someone is going to reasonably think that the person who manufactured this chair is also the person that manufactured the aircraft carrier. So.
Sure. And just to clarify then, obviously trademarks are classified, but what we're talking about here is not necessarily the class. Yep. What we're actually talking about is what's described within the class.
Yeah, exactly. It's the specification of the goods and the services that will be assessed. For me personally, when I'm assessing 2 trademarks, the goods and the services by 2 trademarks, I disregard the class number, and I will look at what's written down in the specification. So some clients will come to you and say, they're in class 9, we're in class 9, sure, the opposition wins. And it's just not that. Okay. Not that simple.
Sure.
I wish that it was. Or perhaps if it was, I would be out of a job. But it's not that straightforward. So there are lots of different goods and services in different classes, and they can conflict across different classes as well. So you could have, for example, software in class 9, or software as a service in 42, or entertainment services conflicting with let's say children's play areas or something. You could have a child's entertainer. So you kind of conflict between goods and services across different classes.
So you need to look at the specifications, basically.
Specifications is exactly where you start for this first part of the assessment. In this case, as I said at a high level, that there was a fairly brief assessment on the goods and services in this particular decision, because most of the goods were identical. Each party had vehicles and similar goods in Class 12, and related software and car batches.
So it's pretty clear. So okay, so what's the second part of the test?
The second part of the test is identifying the average consumer. A slightly strange notion, I suppose, for people that don't spend their time reading about trademarks and looking at them. But the hearing officer will identify the class of persons who is actually going to buy the products concerned. So if you're dealing with high value items, generally a hearing officer will find that the average consumer has a high degree of attention and is more likely to notice differences between trademarks, which in the case of an opponent can make your case a little bit more difficult. However, on the other side of the coin, if you've got an average consumer that shows a low or an average degree of attention, they're more likely to overlook differences. So taking the example here, you've got cars. So most of the time, or especially if you buy a new car or a new BMW, so sort of gone are the days of buying a Volkswagen Golf for £10,000. Now you'd be looking at £50,000 perhaps for a 3 Series BMW.
Sure.
Those kind of purchases, notwithstanding finance deals, they're not entered into lightly.
Well, they're still probably the second biggest purchase you make in your life, right? So for most people, so or maybe the biggest purchase if you love cars.
Yeah.
Okay, so a high degree of attention in this case then.
Yeah, and in a lot of cases, especially if you're assessing a broad scope of goods and services, the average consumer could be held to have a, I suppose, spectrum of attention. Some of the consumers could have a low degree, some consumers could have a high degree. Generally, in this case, a hearing officer found that the average consumer would have a high degree of attention. Like you said, it's one of the biggest purchases you'll make after a house, I suppose. But
sure, yeah, absolutely. So that makes it a bit more difficult to get the opposition pushed through. Then, and then what the third part of the test? Yeah.
So and we'll see the sort of difficulties the average consumer sort of gave rise to in this case a little bit later on. But the third step in assessing a likelihood of confusion case is to look at the trademarks.
Yeah.
Perhaps some people might find that counterintuitive. They might start with the trademarks, but here it's the third step. So we've passed the hurdle of goods and services. We've got identity. We've identified the average consumer, generally with a high degree of attention. Now let's look at the trademarks themselves. It is what it is, really. You're just looking at the trademarks. So there's nothing too fancy about it, to be honest, when we're looking at word marks in particular. So I did pick this decision because it does involve relatively brief words. We're not going to break down, complex logos with words in, etc.
Sure.
So here, the hearing officer has started by providing a short summary, and I will just read what it says here, so you sort of get a flavour for the kind of assessment that they carried out. So both marks are word-only marks. The applied for mark consists of 3-letter sequence BMU. The opponent's early mark consists of the 3-letter sequence BMW. There are no other elements to the overall impression of the marks. So at a high level, that's the assessment they've carried out. They've started with the overall impression, and then following that, they will drill down into the sort of the nitty gritty of it, really. So they'll first look at the visual aspects of the trademarks, the oral aspects, i.e. how it's spoken, how it's pronounced, and the concept or how the trademark was conceived. Is there an underlying theme, so to speak, behind choosing the trademark? In this case, again, we're talking about short word marks here. So visually, they coincide in the first 2 letters, BM. There are comments here that the hearing officer has made that a W is somewhat similar to a U, but perhaps a V is closer to a W than a U is. But in short, they found that the trademarks were visually similar to a medium to high degree. So they've got essentially two and a half sort of letters out of three.
Out of three, yeah.
Are coinciding. Orally, this usually does follow on from the visual assessment because letters are quite often spoke the same as they are sort of observed, so to speak. So B will be pronounced B in both marks. M, and a sort of similar thing here. So they've said B M U or B M W. There is still a degree of overlap, even though that third letter is...
So what was that last letter again?
It's U.
So I thought it was W.
Likelihood of confusion.
Okay, yeah. I don't want us to get confused.
Yeah. So it's... They held that the marks were already similar to a medium to high degree again. So,
okay.
Yeah. So in this case... the hearing officer will always assess the conceptual meaning behind the trademarks, but where trademarks are just comprised of three random letters, which, aside from consumers already knowing what a BMW car is on the face of it and inherently, as the hearing officer would say, it's just three letters. There's no meaning behind them, and same as BMU. There's no meaning there, so they are conceptually neutral.
Sure. So the fourth part of the test is...
Fourth part of the test is assessing the distinctive character of the trademarks. Again, like with point 2 in the average consumer, it can be somewhat difficult to convey in short what the distinctiveness of a trademark is, but suffice to say, at a high level, you could say there are two aspects to the distinctive character of a trademark. That there is the inherent distinctiveness of it, which is assessed aside from any kind of prior use or evidence of use of the trademark. So it's BMW, BMU, both trademarks don't mean anything. There's no concept behind them. They're not descriptive. So if a trademark was descriptive, it could have a low level of inherent distinctiveness, or elusive. If it's a dictionary word, for example. Generally, if you've got short trademarks in terms of their word length, the trademark isn't going to be highly distinctive. So the more distinctive inherently a trademark is, the more easy it is to enforce. And I think that's another important point for prospective clients when choosing trademarks. The more distinctive a trademark you've got, the more inventive and fanciful it is, and the further it is removed from the goods that you've got protected, the better the trademark is. I've handled countless cases where clients have weak or elusive trademarks, and they can be very difficult to substantiate. But in this case, we've got two short words that don't really mean anything, and the hearing officer stated on that, and I will just quote this little passage. The mark is only 3 letters long and is a short random combination of letters, and hence not particularly distinctive per se. So they assessed BMW's earlier mark, and it is the earlier mark that is assessed for its distinctiveness only to a low to medium degree.
Okay.
Now, in isolation, people might think that's unusual. How can BMW not be distinctive? But again, that's an inherent assessment of the trademark. The second aspect of distinctive character is when the prior rights holder has been using the trademark in trade. So they've educated a consumer to identify and to rely on that specific trademark as identifying that business's goods and services. So here we've got BMW is inherently low, or perhaps at best medium distinctiveness, but with the evidence that BMW provided in the proceedings, they managed to elevate that up to a high level of distinctiveness. So again, another point for sort of a practice point, essentially. If you've got a client that is using a trademark in trade, particularly if that trademark isn't inherently the most distinctive, it's always worth filing evidence of use to try and elevate that level of distinctiveness.
Sure. And I think we'd all agree that the enhanced distinctiveness of BMW is probably, I think we'll find out in a minute. Maybe it's critical because
Yeah.
that initial assessment of it not being particularly distinctive has been raised significantly by their use and their marketing.
Yeah.
And everybody knows BMW.
Yeah,
So,
and in this particular case, the hearing officer was quite complimentary of the way in which BMW filed their evidence. I've come across oppositions with very large businesses before, and they take a sort of kitchen sink approach to the evidence. There are evidence rules governing the amount of evidence you can file in proceedings, but they will just whack everything that they've got, and perhaps because they've got so much evidence, it's difficult to sort of hone that down and really just put forward your best case. So I think here BMW were very good in doing that and put forward a really strong case. I think the hearing officer even commented that whilst they didn't file a lot of evidence, what they did file was of really, really good value. So
quality.
It's quality over quantity when it comes to evidence.
Sure. And then what's the outcome, the final part of the test?
So the final part of the test is likelihood of confusion. So that's the fifth step. And by this point, we have assessed the goods and services. That's gone into the pot. We've identified who our consumers are for point 2. We have assessed the trademarks themselves, and we have identified the distinctiveness of the earlier mark, factoring in any evidence to raise the inherent level of distinctiveness. So that's all now in a big proverbial pot, and you're going to look into that pot and see what comes out. At this point in the decision, the hearing officer will usually summarise their findings. So here that they've just briefly summarised the trademarks. The applicant's mark is BMU. The opponent's mark is BMW. They've then briefly commented on the goods. We've got identity and a high level of similarity. They've summarised the average consumer, and notably that they've said the earlier mark BMW is inherently distinctive to a low to medium degree, but the evidence filed by the opponent is sufficient to establish that the distinctiveness of the early mark has been enhanced to very high. So that's the sort of brief summary that the hearing officer will provide when they're assessing the likelihood of confusion.
Sure.
Following that, in this case, the hearing officer essentially said in closing, and this is going back to sort of how the average consumer and the distinctiveness of the market were key to the finding in this case. The hearing officer found that the trademarks were confusingly similar, that there was a likelihood of direct confusion, that there are two different types of confusion, direct and indirect. We'll just look at direct for now. That's essentially one trademark is confused for the other.
Sure.
So he was happy to find that there was direct confusion between the two trademarks. And interestingly, the hearing officer stated that inherently, because the earlier mark was only distinctive to a low, possibly medium degree, and we had consumers that had a high degree of attention, that it was unlikely that they would have found the trademarks confusingly similar without BMW's evidence to prove that the trademark had achieved a higher level of distinctiveness through its use. So, just in closing, the hearing officer stated that the earlier mark has acquired an enhanced degree of distinctiveness, and it has become distinctive to a very high degree in the context of some of the goods which will be selected using a high degree of attention. And my emphasis added, i.e. cars. So
Sure.
If we didn't have that evidence, there is every chance the hearing officer would not have found that those trademarks were confusing would they have been seen on cars.
Yeah.
Which to some people
that might be surprising.
Yeah.
Because it's such a well-known brand.
Yeah, exactly. And I think you mentioned well-known. The hearing officer isn't going to find, take judicial notice and assume that BMW is well-known. I can't think of any case where a business's reputation is that big that it doesn't need to be proven.
Sure.
I suppose you could have some defendants that would just admit somebody had a reputation, but in this case, the applicant did not admit that BMW had a reputation, so BMW had to prove it. They did it well, and even the goods that had a high degree of attention, cars, high value purchase items, the hearing officer still found that they were confusing. So there was a likelihood of direct confusion for all the goods, and the opposition was a success.
So Joel, I think, it's pretty clear then from this case that it's very important to have good evidence. And so a good takeaway for any business, if you're using a brand, you've got a brand registered, then you should be keeping really good track of everything that you're doing so that you can actually build a file of evidence so that if at any point you should unfortunately get involved in opposition proceedings, you can show that you do have evidence of the use that you've been making over time.
Yeah, exactly. It's a really big takeaway from this case. And I think on the point of evidence, it really works for anybody that has a business, regardless of whether you've got a registered trademark. So if you're the owner of a registered trademark, you will want to keep evidence of use of the mark to support an enhanced level of distinctiveness, like BMW did, and also to prove that you're using the trademark in the event that someone claims that you're not. Which is a very common counterclaim that a potential opponent would face. And even for the brand owners or businesses that don't own registered trademarks and just use them on an unregistered basis, having that evidence of use is equally as important, if not more important, to prove that you actually have unregistered user rights in a particular trademark. Of course, as attorneys, we'd always recommend that the trademark is filed and registered. It makes cases like this far easier than relying on an unregistered right. But it's so often I come across clients that perhaps have been trading for 10 years, 15 years or more, and they'll come to you with a case, and they will say, "We've become aware of this business. They've filed a trademark. What can we do?" And I'll start by saying, as part of the case analysis that you're undertaking, you'll say, When did you first use the trademark? And perhaps the business has changed hands. It could very well not be the same person that started the business 10, 15 years ago. And they will say, I don't know. Or they'll say, maybe it was 2005, maybe it was 1995.
Yeah.
And or they will say it was 2005, but we've only got records going back to 2015. So, you've potentially lost out on 10 years worth of solid evidence there that could have been used to support your case. So a massive takeaway, as you rightly said, build good records from the outset.
Sure.
And
don't get caught out.
Don't get caught out. Yeah.
Joel, thank you for taking us through that opposition case and some of the IPO statistics. To our listeners, thank you for listening to our podcast, Figure 1 and IP Conversation. If you run into any opposition problems, then of course, please do give us a call, and we look forward to you joining us next time. Thank you.